Hello again, and welcome to Bar 10 Explanations Negligence Edition. We've got a lot of ground to cover, so let's get right into it. Negligence is when someone fails to carry out certain standards of conduct. It is defined as a failure to behave with a level of care that someone of ordinary prudence would have exercised under the same circumstances. For example, an individual does not carry out an act which a reasonably careful person would, or does something which a reasonably careful person would not do, causing harm or loss to another individual. Primary factors to consider in ascertaining whether the person's conduct lacks reasonable care are 1. The foreseeable likelihood that the person's conduct will result in harm, 2. The foreseeable severity of any harm that may ensue, and 3. The burden of precautions to eliminate or reduce the risk of harm. If you'd like to learn more about this, you can see the Restatement 3rd of Torts, Liability for Physical Harm, Section 3. Negligent conduct may consist of either an act or an omission to act when there is a duty to do so. See Restatement of Torts, 2nd, Section 282. There are 4 key elements in proving negligence. An element is a necessary component of a legal claim. The plaintiff must prove the following in order to prove negligence. 1. A duty of care is the existence of a legal duty that the defendant owed to the plaintiff. B. Breach of that duty. C. Proof that the defendant's breach caused injury, typically defined through proximate causation. And D. Plaintiff's sufferance of an injury. Duty usually consists of required actions, but can also consist of omissions when there is some sort of duty to act, such as a duty to help victims of one's own prior conduct. For example, all drivers are expected to maintain their vehicle in safe conditions and operate their vehicle safely in accordance with all traffic laws. Failure to do so could be seen as violating of a duty. When determining whether the defendant has breached a duty, courts will usually use the hand formula created by Judge Learned Hand in U.S. v. Carroll Towing. For example, a vehicle does not allow enough stopping distance when approaching an intersection and strikes another vehicle that was stopped at a red light. If the burden of taking such precautions is less than the probability of injury multiplied by the gravity of any resulting injury, then the party with the burden of taking precautions will have some amount of liability. Typically, if the defendant had a duty to act, did not act, resulting in a breach, and that breach caused an injury, then the defendant's actions will be classified as misfeasance. There are several ways to determine whether the defendant had a duty to act. I would like to note that this is by no means an exhaustive list. First, the defendant engaged in the creation of the risk, which resulted in the plaintiff's harm. Second, voluntary undertaking. The defendant volunteered to protect the plaintiff from a harm. Third, knowledge. The defendant knows or should have known that his conduct will harm the plaintiff. Lastly, a business/voluntary relationship, such as a business owner and a customer, an innkeeper and a guest relationship, a land possessor who opens her land to the public, as well as a person who voluntarily takes custody of another person. Proximate cause is the actual cause that is also legally sufficient to support liability. Although many actual causes can exist for an injury, the law does not attach liability to all actors responsible for those causes. The likelihood of calling something a proximate cause increases as the cause becomes more direct and more necessary for the injury to occur. For example, a driver doesn't stop at an intersection and strikes a person riding a bike, causing the bicyclist to suffer a broken leg and severe bruising. The pedestrian would not have been harmed if the driver did not strike him. The driver's failure to exercise reasonable care while driving on the roadway is reasonably related to the victim's injury. Typically, in order to meet the injury element of the prima facie case, the injury must be one of two things: 1, bodily harm, or 2, harm to property, which can be personal property or real property. Pure economic loss will usually not meet the injury requirement. Sometimes emotional distress or harm may meet the bodily harm requirement, even if there is no accompanying physical harm. Thank you for joining us on Bar 10 Explanations, Negligence, and allowing me to introduce you to the 4 elements necessary to prove negligence. We'll see you next time, and don't forget, don't text and drive because you owe a duty to other motorists and pedestrians on the roadway. If you breach that duty, you may cause an accident resulting in an injury.